Hey, we are, you can't hear us, but we are Zoom.
Yes, sir. Excellent, excellent. Okay, let me go ahead and swear you in, Mr. Perales. You'll raise your right hand. Sir, do you swear that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given by the witness in this matter now on trial to the best of your skill and judgment, so help you God? All right. And can you go ahead and state your name and license number? All right, good afternoon. This is cause number CR 2410, CR 234, State versus Remedios Mendez Gonzalez. And Mr. McHaslett, do you have any announcement for the court today?
Judge, other than we don't have an agreement, we're continuing working on this, but we don't have the prosecution has conveyed an offer to me. Mr. Remedios Gonzalez has rejected that offer. And at this point, he's choosing to go to trial on this case.
All right, I show that we're set for pretrial today. Are there any contested pretrial matters that the court must undertake?
No, Your Honor, we've been given everything. I've met with Ms. Heidel in the office and gone over all motions that we had, and we agreed on everything.
Okay, so do you want the court to go ahead and set your client for trial, or do you want the court to set your client for docket call so that he has a little more time to make any counter offers and it extinguish the possibility of a plea negotiation?
Well, Judge, I think at this point, probably to get down to the nitty-gritty, we have to set this case for trial.
Okay, and so does your client understand that by rejecting any plea offer or any counter offers and not going to a plea agreement today, does your client understand that the court will not accept a plea agreement after today? Even if the state comes back and says, we're going to offer him a misdemeanor, court may not entertain that, and I may make your client plead open, and he may get better, he may get the same, he may get worse.
Judge, I did not discuss that, so I have to court to set it for one docket call so that we can talk about that. I feel like I can ask the state to give me their best offer.
Okay, I think that would probably be wise, but I do want him to understand that. Let's see, what date did I set you for earlier, Mr. McHaslett? Was it September 14th or 16th?
16th.
It was the 16th? Okay, let me make sure I don't spread you out on different days. So the court will set this on September 16th at 1:30. If your client is still in jail, it'll be at 9 a.m. if he makes bail in this case, and it'll be set for docket call. And on that date, I will expect to hear from the defendant whether he wants a jury trial, bench trial, or a plea agreement.
Thank you, Ron.
Mr. Perales, if you could ask the defendant if he has any questions or if there's anything that he's unclear of today.
No, todo eso está bien. Todo está bien. Lo más está esperar el otro.
Okay, if nothing further, then we'll see Mr. Mendez back on September 16th, and we'll be adjourned in this case.
Thank you, Judge. My beef too.
Yes, thank you, Mr. McCaslett. I appreciate it. Perales, I believe that's all we have for you today. I think our system worked pretty well. What do you think? Kudos to you, Mr. Perales. Kudos to you. Yes, sir. Will do. Have a great day.
And Judge, we got pulled in late on that last one. I got the gist of resetting it for docket call, but was there any other important announcement the statement?
Mr. McHaslett indicated that an offer had been made, that his client had rejected that offer and was wanting a jury trial. I discussed with Mr. McHaslett the court's policy of the defendants passing docket call and not being able to enter into a plea agreement after that. And then Mr. McHaslett opted to request one additional setting for docket call so that he could explain that to his client, that his client may not be able to enter a plea agreement in after docket call. And I posed it even if the state were to make a better offer than they made today, the court may require him to plead open and then he could get better, worse, or the same.
Okay, thanks, Judge.
So we just reset that to September 16th. All right, Ms. Tabram, do we have anyone else that's ready?
Yes, sir. Mr. Adams is ready on Kevin Wood.
CR 29-6, State versus Kevin Lee Wood, set for motion to revoke. Go ahead, Mr. Adams.
Afternoon, Your Honor. We're not ready to proceed on the information received from the state earlier this week or yesterday. It's our understanding, according to the DA's office, that they are under the impression that an indictment in federal district court is anticipated for what sort of case or charge, I don't know. I understand it may involve game awards or something of that nature, but in light of that news, assuming that news is accurate, the state's attorney and I agreed that it is most prudent not to proceed on this matter today in order that the federal case can be dealt with, or we can find out or figure out whether or not there will in fact be a forthcoming federal criminal case.
Is the federal case an alleged violation in the motion?
No, Your Honor, this is a new investigation that we just recently found out about. I'd actually made an offer to Mr. Adams, but we at this time are going to withdraw that offer just until we get the information from the feds to see if that would impact our offer in any way.
Do we anticipate that the federal authorities will pick up Mr. Wood to take him into their custody?
Judge, I'm not sure where in the investigation they are. I just know that there is an ongoing investigation. So that's why we were going to request a reset to see if we could get that information so that we'd all be in a better position to make a decision on this case.
My concern is that we him in custody for an indefinite amount of time, waiting on an agency that we don't have any direct connection to, or it's not relevant to this charge. I understand that he may have other liability and exposure out there, but my concern is that we don't know when that's going to occur and he's just going to sit in our custody. I think the latest that I'd be willing to set it for would be for the contempt docket on September 30th, and that's 45 days away almost.
To that end, Your Honor, based on the state's representation to me about the status or potential status of the federal case, Mr. Wood has been in custody since July 16, I think, on a no bond. $150,000 bond. I'd ask the court to consider, if not a PR bond, at least a bond reduction, if it's going to be 45 days before we can come back.
I would have concerns about resetting a case because he may have a new federal charge. I'm not sure I'd be inclined to let him out if what we're doing is resetting this case because he has additional charges outside this county. So I could, I can set it for 2 weeks and we can do a contested hearing on the 26th. State can move forward on their allegations. And then the court could make a determination on whether he violated his community supervision or not. We can resolve it that way. And then the federal authorities can do whatever they want with him at that point.
What would the date be for 2 weeks out, Your Honor?
It'd be August 26th. It'd be 2 weeks from Thursday.
And Judge, the state will do its very best to get more information by the 26th to see if we can't move forward with our agreed disposition on that day. If not, we'll be prepared for a contested hearing.
We'll be ready on that day, Your Honor.
Okay,
I've got
so
I
go ahead.
I do have a case on a district court docket in Smith County for trial that week, but I understand I'm pretty far down on the docket of them. That includes 100+ cases. So.
Okay, so what we'll anticipate is on the 26th, we'll either have a agreed plea or we'll have a hearing. And we'll set that at 1:30. We'll set that at 1:30 that afternoon.
Yes, sir.
Is there a agreed statement possible or what?
All right, Your Honor.
If there's nothing further than August 26th at 1:30.
Yes, sir.
If he makes bail, then that will adjust the case time to 9 a.m.
Is there any bond change?
No, there's no bond change.
Your Honor, Joseph Bogan's ready on Richard McKnight.
CR 17-206, State versus Richard Wayne McKnight. I show that it's set for recusal status. I'm not familiar with, is this a recent motion to recuse, Mr. Hogan?
No, Your Honor, this motion was actually filed, I believe, at the very beginning of 2019. We never had a hearing on the recusal motion. I filed today and served the state with a speedy trial demand as well as a notice of withdrawal of my motion to recuse. I am also formally withdrawing my motion to recuse today, announcing ready and requesting the first available jury trial date that we can get that works with the court's calendar and my calendar as well.
When was our last hearing on Mr. McKnight's case?
I believe it probably would have been near the end of 2018. He missed a court date. Had a bond forfeiture, a warrant was issued, and he was not picked up until, I believe, last month.
Okay, so he was an absconder and has been recently taken back into custody. Okay, that makes sense.
Yes.
All right, and let me see here. Okay, before I place Mr. McKnight on the trial docket, can I hear what the offer is from the state so that I know that Mr. McKnight is formally rejecting that?
Yes, Your Honor. Previously, this is a state jail felony. It came to my attention upon review of this case. I was not the previous attorney on the case. It came to my attention that Mr. McKnight had priors. I have filed a Brooks notice. So we plan to proceed under the Brooks notice, to which he will be 2 to 20. The state's offer is 6, and that is our best offer.
6 years TDC, is there a fine?
Judge, I believe I said 2,500, but I don't remember particularly.
Okay, and Mr. Bogan, you've communicated that to your client?
Yes, I have. My client has rejected that offer, and we are ready for trial.
Okay, and he understands that by rejecting that offer and going on the state's or on the court's trial docket, that the court may not allow them to accept a plea agreement after today?
It is, yes, I just explained that to him as soon as he walked into the courtroom.
Okay, and so any plea request after going on the jury trial docket will have to be done by an open plea. Understand?
Understood.
All right, the court will place Mr. McKnight on the jury selection docket beginning August 30th. And Mr. McKnight will maintain on that docket until his case is called for trial. So Mr. McKnight, if you make bail in this case, then you're going to have to report to the courthouse at 8:30 on those dates and meet with my staff, who will be down in the basement of the courthouse, and they can give you additional information about the next setting. If you remain in custody, then we'll just have the paperwork sent out to you.
Are we excused, Your Honor?
Yes, yes. Once he gets his notice of setting for that jury docket August 30th, then we'll be adjourned in this case.
Thank you.
Thank you.
Thank you, Mr. Bogan.
Okay, Your Honor, Richard Smith is ready on Carl Fulton.
Carl Fulton, CR 21176, set for pretrial. Go ahead, Mr. Schmidt.
We don't have any contested pretrial at this time. We'd ask them that to set for docket call.
All right, court will set for docket call on September 14th, 9 a.m. I'm sorry, 1:30 if he's in jail, 9 a.m. if he's on bail.
Thank you.
Did I hear you say you're ready on Mr. Brown?
Yes, sir.
Ronald Franklin Brown, CR 2114.
Judge, we have two cases. We have the MPR as well as the pretrial on CR 2114. We don't have any contested pretrial on that cause as of today's date. Ask that matter be set for docket call and carry the MTR with it.
All right, court sets Mr. Brown for docket call on September 14th and motion to vote even date.
Judge, we had Tessa Fern on the docket for pretrial. It's my understanding from Ms. Abraham that she's in Henderson County. We should ask that be set for an additional pretrial.
Cause number 2019-423, CR 21-124, State versus Tessa Marie Fur. Each case is set for pretrial. Ms. Fur is being housed in the Henderson County jail. And Henderson County, my understanding, is in having some COVID quarantine issues. She's not been transported to Van Zandt County. Court will grant the request to reset pretrial. Will reset to September 14th.
Thank you.
Are there any trial issues regarding discovery or anything that we need to put on the record that you need from the state?
As far as Ms. Fur's concerned, I think that we finally got the remainder of what I thought was outstanding. So at this point, as far as discovery is concerned, I don't believe that there's any outstanding.
Okay.
Your Honor, it'll be just a minute before we get the next setup.
Who do you have?
We have the rest of yours coming up. We have the rest of Mr. Schmidt's coming up. And then we'll, Waynet said that Ms. Thompson is on.
She is.
Okay, so we will get hers. If y'all will just let me know when Henderson County appears, because I can't tell over here.
Okay.
Put them in a breakout room to go over that plea.
So whenever Henderson County zooms in, put them in a breakout room with who? Mr. Adams. I'm sorry, I couldn't hear you.
Mr. Adams is here in the courtroom. We're gonna move him to a room so they can go over the plea. And then when they're ready, just come back into the courtroom.
Okay. Mr. Schmidt, we do have Mr. Mata here at the courthouse on Zoom. Do you want to speak with him in a breakout room while they're pulling up inmates, or do you want to give him a call, or how do you want to handle that?
Yeah, Judge, actually, I believe they're bringing the rest of my folks up. And after that, if it's okay with the court, I'll just come over to the courthouse.
Yeah, that's fine.
Okay, that's what I'll do then. If he'll just
Okay.
wait.
Okay. I'll pass word to Mr. Mata.
Thank you, sir.
discussion first? Ms. Beasley in a plea or Mr. Schmidt and his other quick ones?
I got a couple of announcements.
All right.
I'm good. I've got a few others.
Are we ready on Horton?
Judge, I think Mr. Horton is, he's having a mental day. And we're set on a pretrial. I would tell the court that previously I had concerns and we brought him to the court's attention about his mental health. The last time he was in court, he appeared to be fairly stable. Apparently that's reversed itself. So I would ask, and I haven't spoken to the state, but I'd ask that he get an additional pretrial setting, and then I need to figure out what's going on with his mental health. So
The
he will
state-
not get court.
State has no objection, Your Honor.
All right, court will excuse Mr. Horton from appearance today. We'll set the first case, the 2021 case for docket call on September 14th, and pre-trials in the other cases same day. Do we have Daniel Larsey?
Yes, sir.
Mr. Larsey?
Judge, on, are you gonna, I'm sorry. I
Go-
didn't
Yeah,
mean-
yeah, go ahead. Go ahead.
Okay, we're set on pretrial today. I did speak with Ms. Heisel this morning, attempting to negotiate some resolution. I filed a motion to suppress in the 7-9. I'd like to have that set for a contested docket date. And that's the man delivered, I think it's 7-9.
I believe the manufacturer delivery is 7-8 and the evading arrest is 7-9.
Okay, then it's 7-8. That, my intent was to file in the man deliverer. I'm fairly certain I did. I just, I don't have my docket in front.
Okay, court will set cause number CR 2178 for suppression on September 30th. And that'll be at 1:30. And then the remaining cause CR 2179. There being no contested pretrial motions in that case, the court will set that for docket call on the same date. Is Mr. Powell ready?
Yes, sir.
CR 21235, State versus Gerald Wayne Powell for arraignment.
That's correct, Judge. Received a copy of the indictment. Mr. Powell's first name is in dispute. His birth name, I believe, is Gerald, as spelled in the indictment. He was adopted at some point, and it may be Jerry. It's his current legal name, Jerry, correct?
Correct, yes.
And Judge, I can verify that I've sought some records from the Dallas VA, and they have him under Jerry, Jerry. Other than that, we understand what he's been charged with, range of punishment. We waive formal reading of this indictment, enter plea not guilty for today's purposes. In addition, I have filed a notice of an intent to raise the insanity defense at some point, and I believe most likely at a pretrial hearing, we'll need to discuss whether or not we're going to get an independent or a court-appointed evaluation for the purposes of that code. But at this point, we just ask that it be set for a pretrial.
State.
Judge, the state is going to be filing a motion to procure its own experts for that matter. And in addition, if we can get any kind of documentation showing that his name has been legally changed to Jerry, we would just ask the court to interlineate in its record on the indictment.
So there's no motion at this time, correct, from the state to amend the indictment to correct the spelling of the name?
Yes, Your Honor, we would move for that at this time.
So the state's making an oral motion to amend the indictment to change the name Gerald Wayne Powell to Jerry G-E-R-R-Y, Wayne
J.
J.
J-E-R-R-Y.
J-E-R-R-Y, Jerry Wayne Powell.
Correct, sir.
All right. Any objection from the defense?
No objection, Judge.
All right, court grants the state's oral motion to amend the indictment. Court will interlineate the name Gerald and replace it with the name Jerry, J-E-R-R-Y, Wayne Powell as the name of the defendant. Court will enter Mr. Powell's plea of not guilty into the record. We will set this for a pretrial hearing on September 14th, and we'll also go ahead and set it for evidentiary hearing on, do you think we'll go ahead and have an evidentiary hearing set on the 30th? I think that's too soon.
Actually, if I could, a lot of the motions that I intend to file on Mr. Powell's behalf are dependent on receiving records from the Dallas VA. The good news is I've actually spoken to a human, so they've got my request and it's in process. I would ask that the pretrial be set 60 days out so I can get those records back. I understand Mr. Powell's in custody, but this is going to be a complex process considering the nature of the evidence.
Objection from the state?
Good afternoon, Your Honor. We did receive the notice of intent to raise the insanity defense filed by the defendant. So under the statute 46C, we're entitled to have the defendant examined, and we will be filing that either this afternoon or tomorrow to have him examined by a psychologist and a psychiatrist, Judge.
Okay, any objection to setting this for the next hearing, say October 12th?
For a pretrial, Your Honor?
Yes, ma'am.
Perfect, Judge.
Okay. All right, then we'll set it on October 12th at 1:30. And I'll look for those filings and sign any order that's necessary. Ms. Abraham? Is that all you?
Yes,
Schmidt? Is that all you have, Mr. Schmidt?
That's all I have, Judge. Thanks.
Okay, Ms. Abraham, I believe that I do have the Henderson County Jail. I'm going to bring them in. And Mr. Adams in a position where he can.
Yes, sir. He's in the attorney room. He should be ready to go into the breakout.
Affirmative.
All right, let's bring the jail in and see if this is the. Okay, great. Ms. Attilo and jail staff, what I'm going to do is we are present in court. Mr. Mitch Adams, counsel for Ms. Attilo, needs to speak with her in a breakout room on Zoom to go over some plea papers, I believe. So what I'm going to do is send you an invitation to join a breakout room. You can just click accept the invitation. Then Ms. Attilo and Mr. Adams will be in a breakout room, and then
He said that you're going to have to click to accept the invitation.
and whenever you're done, you should be able to come back to the main session, or just stay there, and Mr. Adams can come back and tell me when he's ready. So
Okay. There should be a link to join the session.
yeah, in just a second, it's coming to you right now.
Oh, there it is.
And let's see, Mr. Adams, you are titled District Courts W. Let's see.
Got it.
Ms. Bixley, who are you ready with? Your Honor, Ms. Beasley is ready with Michael Williams for his plea.
All right, and if somebody, before I go ahead and start this, if somebody can give me the terms of the plea, and this is CR 21-200 State versus Michael Williams, second degree felony, manufacture, delivery of a controlled substance, I believe PG1, is that correct?
That is correct, Judge. 1 to 4 grams, and the state and I had discussed with the court this morning about an agreement to orally amend the indictment to correct it in the body. In the very bottom of the body of the paragraph, it says in the last sentence, an amount of 4 grams or more, but less than 200 grams, and it should be in an amount of 1 gram or more, but less than 4.
All right, and is that your motion?
Yes, Your Honor.
State, is that your motion? It's your indictment.
Judge, that is our understanding as well in reviewing the evidence as the state believes it to be. It should be 1 to 4. Still should be a second degree based on the manufacturing delivery, but the amount should be between 1 and 4 grams.
Okay, court will grant the motion to amend the indictment to reflect the correct amount of controlled substance alleged to that of one greater than or equal to 1 gram, but less than or equal to 4 grams, a third degree felony amount, but enhanced due to manufacture or delivery or possession with intent to a second degree. And what are the proposed terms of the plea today?
Yes, sir. It's 6 years deferred probation, $2,000 fine, $180 restitution, court costs of $290, reimbursement fees of $985, 1245, an unindicted new charge of fraudulent use or possession, probably supposed to be of identifying information, but they listed it as credit card abuse, Judge. Charge.
So let me repeat that. 6 years deferred, $2,000 fine, $180 restitution, $290 court costs, $985 reimbursement, and then the state is rejecting a credit card abuse.
That is correct. Or credit card or fraudulent use of possessing with identifying information. It was a hybrid charge.
Is there
Name.
is there a number associated with that so we can be precise?
Yes, sir. It says GT, capital G, capital T is in Tom, 5 LT 10.
That's the DA number?
That's the number that they put on this paperwork to identify it, Judge.
Judge,
Okay.
I'm not sure if that's the bookend number. The state only has received 1 case, and that's the indicted case. We have no other pending charges for Mr. Williams.
Okay, so it's George Thomas 5, Lincoln Thomas 10, correct?
Yes, Your Honor.
Okay. All right, Mr. Williams, if you'll raise your right hand, place you under oath. Mr. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. You are Michael Williams, is that correct?
Yep.
Yes, sir.
Yes, sir.
Williams, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Deborah Beasley. Are you pleased with her representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with her and have all your questions answered?
Yes, sir.
Is there anything about the plea papers that you've read and signed that you do not understand?
No, sir.
And did you place your true and correct signature throughout that paperwork?
Yes, sir.
Ms. Beasley, do you believe Mr. Williams to be competent today?
I do, Your Honor.
And you've explained to him his legal rights and also explained to him the advantages and disadvantages of a deferred adjudication plea?
I did, Your Honor. He understands all of the consequences of deferred and still wishes to enter a plea at this time.
All right, Mr. Williams, you are charged by indictment, which has been amended today on the record of a charge of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams, which is a second-degree felony, which carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
And you heard Ms. Beasley read to the court what the plea agreement was in this case. Is that your understanding as well?
Yes, sir.
All right, understanding the range of punishment in the plea agreement, then, Mr. Williams, how do you plead to manufacture or delivery of a controlled substance in penalty group 1?
Guilty.
Are you pleading guilty because you are guilty of committing that crime? Say it a little bit louder.
Yes, sir.
Okay. I have a court reporter who's here in the courtroom with me, and if she can't hear you, she can't type it down. Mr. Williams, has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt. Ms. Beasley, any objection to states 1?
No, Your Honor.
All right, states 1 is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
I'd ask that my client be allowed to testify, Judge.
Yes, ma'am, go ahead.
State your name for the record, please.
Michael Williams.
Mr. Williams, I got appointed late yesterday afternoon, and I was at the jail before court this morning to talk to you about your circumstances. Is that correct?
Yeah, that's true.
You told me everything and all the information, and were quite honest with me about laying out everything that happened in both of these 2 cases before the court at this time. Is that correct?
Yes, ma'am.
You asked that I try to go over to the DA's office and get something resolved with a probation, preferably deferred probation.
Yes, ma'am.
And so I went to the DA's office, spoke with Ms. Curry, the DA herself came back to you and explained what the plea offer was, and you asked that we carry this and get it done today. Is that correct?
That's true.
You understand that I've seen the police report, you and I've gone over that information together, but there may be DVDs or other things that are available, and I've not seen those DVDs. You understand that?
Yes, sir. Yes, ma'am.
But you and I've seen the police report, you admit that you're guilty in both of these offenses.
Ms. Beasley, I'm sorry to interrupt, but if there's anyone else that's talking in the courtroom close to the microphone, we are picking that up more than we're picking up Ms. Beasley and the defendant. So go ahead, Ms. Beasley.
So even though I just met you yesterday, you admitted your guilt in both of these cases. You wanted them resolved as quickly as possible. You indicated to me you wanted to do this as soon as possible if we could get a plea offer on probation. Is that correct?
Yes, ma'am.
And so you understand we don't have to do a plea today. We could reset it, give me time to go out and look at the DVDs, but you and I've talked about everything, and I've explained to you everything that you told me this morning is reflected in that police report that I got this morning.
Yes, ma'am.
And you understand everything you're doing, you still want to proceed.
Yes, ma'am.
Pass the witness.
Any questions from the state?
No, Your Honor.
All right, state.
Rest of the-
Thank you, Ms. Beasley. State, can you present me with the evidence to support the plea?
Yes, Your Honor. On December 18th of 2020, Mr. Williams was driving a vehicle that was pulled over by Grand Saline for failure to maintain a single lane. I believe there was also expired registration on the car. The driver immediately admits that he has no insurance on the car. The Grand Saline officer comments to him that he looks nervous. He also sees drug paraphernalia in plain view. He then asks Mr. Williams if he can have consent to search his vehicle. Mr. Williams consents to the search. He admits to a small baggie of drugs being in the car. They do a thorough search and they locate multiple sizes of baggies, packaging materials, a set of scales, and then under the seat there is a larger bag of methamphetamine that is found. Mr. Williams admits all of it's his. He tells the officers he forgot about the bigger bag, or he would have told them about it sooner. But he admits that it's all his. The lab comes back at 3.02 grams of methamphetamine.
Any objection, Ms. Beasley?
No, Your Honor.
All right, then based on the evidence as presented and the recommendation, court will follow the plea agreement in this case. Court finds that there's sufficient evidence to convict Mr. Williams of this offense. However, the court will defer a finding of guilt, place the defendant on 6 years community supervision, order him to pay a $2,000 fine, $180 restitution, $290 court costs. Also orders him to reimburse Van Zandt County $985. Court also finds that the state has agreed to reject and consider into this plea under section 1245 cause represented by identification GT5LT10, a credit card abuse or fraudulent use in possession of identifying information. Mr. Williams, you are hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted, after which you will speak with the probation department and they will give you more information on your next step.
May he be excused, Your Honor?
Yes, ma'am. Thank you. And Ms. Thompson is online, and so is Mr. Ashmore. So if any of his clients or her clients are available, then we can call them up.
And we have those three coming up now on Lauren Foley. The jail just notified me that she is also in Henderson County.
Are all females in Henderson County? So that we can prepare for Thursday's docket as well.
Okay, Ms. Beasley is ready on the plea on Mrs. Heflin.
All right, this is cause number CR 16592, State versus Carrie Heflin. Ms. Heflin, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, and is this going to be a plea of true today to all counts alleged in the state's motion?
Yes.
Mr. Woodward? Do you want to tell the court what we're doing?
Judge, we are agreeing to withdraw the state's motion to revoke. We are extending, I believe, 18 months and adding as a condition of probation that Ms. Heflin check herself into the Genesis Center in Kaufman, where she will do drug rehab. I believe there are some additional attorney's fees, which I am unaware of what exactly that would be.
There'd be an additional $500 for today's representation, Judge, and in addition, a condition that she report to the Genesis Center within 1 week. She has 1 week to get there and start complying with their conditions.
And have we evaluated the Genesis Center for their drug rehabilitation program? That's kind of an open-ended question, maybe for probation to chime in.
Yes, we have, Judge, and they have beds available for her to report.
Do we feel confident that they have a program that will be able to assist her in her drug addiction and rehabilitation?
Yes, sir.
Okay, so you're comfortable with it?
Yes, sir.
Okay.
And it's a 1-year program, Judge.
So Ms. Heflin, if I allow you to do this, you're going to go over to the Genesis Center and you're going to take advantage of the opportunity that you've been given, and you're going to work to get rehabilitated on your addiction.
Absolutely.
You're going to give it. You're going to give it 110%.
Absolutely, yes, sir.
What happens if you don't?
I understand that I will be going to prison,
For how long?
2 to 10, sir.
What did you agree to when you went on probation?
5 years probation,
10 years probation.
10 years probation for 5.
So how long do you go to prison?
At least 5.
Say again?
5, yes. At least 10.
Is it 5 probated 10 or 10 probated 5?
It's
10 probated 5, Judge.
It's 10 probated 5. Okay, so how long do you go to prison then if you violate?
10 years, sir.
10 years. So
Yes,
I want
sir.
you to think about that. That should be another part of the reason, not only, I mean, the best reason to get rehabilitated is so you can take control of your life and be healthy and productive and be restored to society. That's number one. If you need fear in your life, then you can use the 10-year sentence as fear.
Oh, yes. Yes, sir, for sure.
Okay, the court will, based on the recommendation of the state, the court will grant the state's motion to withdraw and extend the community supervision of Ms. Heflin for the period stated in the paperwork. I believe it's going to be 18 months to, hang on just a second. We had a little technical difficulty here. Can you hear me okay? Okay. Ms. Beasley, can you hear me okay?
Yes, Your Honor.
Okay.
State can hear you as well, Judge.
Okay, good. We've had a little bit of an issue over here. So the court will amend the conditions of community supervision to require Ms. Heflin to attend the Genesis Center drug rehabilitation program for the period stated, and will amend the conditions of community supervision to account for additional court costs and legal fees in this matter. So Ms. Heflin, you know, I'm not going to say good luck to you because it's not about luck. Luck is just something you happen upon. It's about hard work and commitment and dedication. So I'm gonna leave, those things are up to you. I can't do that for you. You can do it for yourself. Okay. So go work hard on it.
Yes, sir, thank you.
Has she been excused, Your Honor?
Yes, ma'am. Just make sure that she has signed that extension of her community supervision.
She did, Judge.
Okay, thank you, Ms. Beasley. All right, give me just a second. I'm gonna reboot Ms. Grisham's computer so she can see you all. Take just a second.
Yes, sir.
Here, Mr. Myers. Here, Mr. Myers.
Yes, ma'am.
I sent my son all of the cases that I had, gun folders. I just started sending them request for discovery, request for discovery, request for discovery, so it's documented. I make a phone call when I went through it. And the report.
Hey, Paige, well, we're waiting. Bill Stevens is too?
Yes, ma'am.
Are either of those a plea?
Yes, ma'am. Pesnell. One. And so is Blevins, and that's the one we're gonna do outside of the car.
So I do have something.
And I don't know about this secret, I went with the
And
boyfriend.
I read a little bit of the police report to him,
Secret was supposed to report here.
but it says actually a copy, and I go over it. And I go over it. Okay. And I'll try to find a chance to come up with it.
I thought I heard an APAL in progress when I was walking through that room.
But I didn't want to let you know we got something.
One of you was asking, "Are you feeling hurt yourself?"
Yeah.
Judge Conway said, yeah. No. And I did talk to the ZBA and she's not willing to agree. So we'll talk about that. I did go over and try to talk to her about something.
Mr. Sims is here.
We're gonna remodel the house and have a bunch of stuff in the car. I knew it was something she wrote.
Was that it? I thought it was me on the phone.
No, when I shut it long ago, it was making noise. What's it doing? They're having some kind of problem with Stella or something.
Our new phone lines here Friday. Oh. I'm being, I get it.
I get it. I actually understand your hand.
Oh, our earphones did good today.
Again, yes. I used it twice now. So
Everything.
when they do the OCA interpreter via Zoom, you know, used to have, you had to have a remote location. No more. Now they stand right next to their attorney, the headphones,
And I can hear it.
the Spanish speaker can hear the interpreter, but it all flows like.
Well, that's awesome. That's awesome.
Okay, Mr. Adams supposed to be through. He's headed this way with a computer, except he got,
I think I should have stopped and done what Karen did and got something from the science director.
he got sidelined.
She's getting professional at these meetings. She knows how long they're gonna last.
Okay, we're ready.
You want to finish up with Ms. Paisley?
Yes.
Got Mr. Ogletree, Your Honor.
Hang on just a second till I get this out.
Yeah, is there another laptop in there? You're in a pretty bad echo.
You still hear a bad echo, Your Honor? I think I got it turned off.
If Mr. Adams brought that laptop in that he was on, I think that was probably causing a feedback, causing a loop.
Yes, sir. Do we sound okay now? Is it fixed now?
Better. Yes, it's better now. All right, this is CR 21-136, CR 21-182, State versus Philip Andrew Ogletree. We are set for pretrial.
Yes, Your Honor. I still need discovery. I just received 2 DVDs today, but I don't have access yet to the police report. I know that the DA's office is working really hard to get me that information. So I'd ask for additional pretrial setting.
I was waiting to see if the state wanted to respond.
Judge, I know that Ms. Beasley has put in that request and we are working on it. It's my understanding that we do not have it ready yet, but we will let her know as soon as we are able to get that produced for her.
Okay, court will set Mr. Ogletree for pretrial on September 16th. I believe that's the date you requested earlier, Ms. Beasley, is that right?
That is correct, Your Honor, but that's getting a little full. Could I have that one set on the 14th, please?
Well, my 14th is,
Full.
yeah, it's getting at capacity as well. I've got more availability on the 16th. I think we set you earlier for the 16th though.
We did, Judge, but it's getting filled up, so for me, so, but if you want to do the 16th, we'll do the 16th, because it's gonna be a long afternoon.
Yeah, let's do the 16th. Otherwise I'll have a super long afternoon on the 14th and none on the 16th.
Well, of course, it's gonna be all night. Okay. Yes, sir.
And so before,
1:30 on September 16th.
yes, and before we are adjourned in this case, Mr. Ogletree, I don't, maybe I've misheard, but the word that I get back here at the courthouse is that you're not treating people well. Is that rumor true, not true? Have you had an attitude? Are you disrespecting visiting judges and court staff? And are you doing that to Miss Beasley as well?
No, sir. I've had no issue with my client.
I haven't.
You know what I'm talking about?
No, Your Honor, I don't. I haven't had any issues, disciplinaries, not on restriction for anything. I haven't been written up.
And no one's told me anything, Judge. And honestly, this client has been nice and polite and has shown no attitude towards me whatsoever.
Were you in court last week with Judge Brabham?
No, sir.
You are?
Oh, yeah, for Attorney General.
Yeah.
Yes, sir, I was. I was polite with him. I had a couple of questions as to why I was there, but they were quickly resolved.
So if I'm hearing otherwise, then there is a mistake?
Yes, sir. I'm not going to lie to you, Your Honor.
All right. Well, I'll look into that and I'll let you know if I find out otherwise.
Yes, sir.
And if you think I'm going to, now would be the time to tell me.
Your Honor, like I said, I have no reason to lie to you at all whatsoever. So I'm not quite sure what information you've gotten back to you. I was in court last week for the Attorney General to grant full custody to my children's mother. Because I'm incarcerated, so that they could have full benefits from the state. I just was a little confused on a couple of things that they were saying. I just wanted to make sure that the custody was going to be in the mother's full possession. I wasn't quite understanding of that. So other than that, there was no disrespect or out of line, out of place. I didn't cuss, rant, and rave, or anything like that.
Okay. Well, I hope not. So I'll kind of go back and see what I've been hearing and find out more about that. And if I have more concerns, I'll let you know.
Yes, sir. Thank you.
All right. You're welcome.
May he be excused, Your Honor?
Yes, ma'am. We'll see you back on the 16th.
Yes, sir.
Thanks, sir.
Mr. Adams, are you ready?
Yes, Your Honor.
All right, let me see. Ms. Tolo.
We do have a technical issue. The jailers over in Henderson County, they left out of the room before I could ask Ms. Attilo whether or not she had a writing instrument. She did not. She said that they were not within view of the room that she was in. Nevertheless, I went ahead and proceeded with Ms. Attilo to go through all of the documents in the plea, and that she and I each had a copy of in the plea paperwork. I pointed out to her signature line on each of the documents. Before doing so, I routinely asked Ms. Attilo as we went through those plea documents whether or not she had questions or understood everything. As we went through, she consistently stated that she did understand what was contained in those documents. She just doesn't have a way, or didn't have a way, of signifying her understanding by signing her name to the document.
Okay, let me see if I can get her moved back and we'll solve that problem.
I could go through that with her again when she's on the record with us.
And then if we can remind them that we need those papers
Oh,
faxed or emailed back today. Okay.
The system won't let me just move her in. I think she probably has to click on something and she's not. So I've done a force closeout. So 20 seconds T minus, she'll be moved. About 5 seconds, she should be coming in. Yes, good. Can you hear me?
Yes, sir.
Still, okay, excellent. Hey, it's okay. So before we go any further, can we, before Ms. Attilo is finished today, we need to make sure she gets a pen or something so she can sign the documents. So Ms. Attilo, can you make sure you get that done?
Yes, he just left. I'm gonna have to ask him again.
Oh, sorry, I was trying to catch
It's
him.
okay. Let me push the button.
He's real quick.
Okay. All right,
Yes,
so let's.
I'm needing a pen so I can sign these documents.
Is he gonna bring you a pen or a pencil?
I'm thinking so. They didn't say nothing back.
Hopefully a pen. Okay. Well, when he comes in, if he comes in, tell him to hold what he's got. Tell him not to leave if he will. I need to ask.
Okay.
Okay. So in the meantime, let's raise your right hand. I'm going to place you under oath. Ms. Attilo, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. You may put your hand down. Your name is Jessica Lisa Attilo. Is that correct?
Yes, sir.
And Ms. Attilo, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Did you say yes?
Yes, sir.
Okay. And do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed with him today and that you're going to sign that you do not understand?
No, sir.
And Mr. Adams, do you believe Ms. Attilo to be competent today?
I do, Your Honor. She's legally competent.
And you've explained to her legal and constitutional rights?
That's correct, Your Honor. We went through the court's admonishments page by page, paragraph by paragraph. She understands what it is that she's charged with. She understands that it's a state jail felony and what the range of punishment is. She acknowledged her understanding of our plea agreement with the district attorney's office in exchange for the plea agreement. She understands all the constitutional rights that she has that are described in that document of admonishments. She understands that agreeing to the state's offer that she is waiving those constitutional rights, including her right to appeal what happens here today. She indicated to me that she is a U.S. citizen. The admonishments contain several paragraphs concerning the concept of deferred adjudication probation, which does not apply to her or her situation here today. She understood she acknowledged her understanding of the language in the admonishments whereby she acknowledges her guilt in the offense with which she is charged and enters a written judicial confession.
Okay, yeah.
Did you get the?
He brought me a pen, yes.
Never. Okay. And finally, Your Honor, she voiced her or acknowledged her understanding to the contents and language contained in the trial court's certification of defendant's right to appeal, the state's certificate of discovery, and a stipulation of evidence.
Thank you, Mr. Adams. So I see here that the agreement is that Ms. Attilo is going to be pleading guilty to abandoning or endangering a child with criminal negligence. State's recommending 6 months confinement in TDCJ, State Jail Division, $2,500 fine, 42 days total time credit towards her sentence, $290 court cost, $35 reimbursement fee. Is that correct, Mr. Adams?
That is correct, Your Honor. To the extent that I believe Ms. Attilo has 43 days, which would include the day that she was originally arrested back in 2019.
State, what do you say? This says 42.
Judge, we may not have counted the day she was booked in. We'll give her the 43 days credit. Will state jail let you interlineate that, or will we need a new front page of the judgment?
TDCJ usually won't take anything that's been marked out.
Okay.
However, we may be able to white that out and fix it once we get over here.
Whatever the court needs, if you just need a new copy, just let Ms. Abney know and we can get that to the court before it gets sent to TDC.
You know what, I'll need a new front cover, just a front page with 43 days, and we'll just have Henderson County email us the fingerprint page and we'll replace it. That'll work.
Okay, I'll email it to Mr. Abraham. Thank you, Judge.
Okay, so Ms. Attilo, is that your agreement?
Yes, sir.
All right, Mr. Attilo, the range of punishment for a state jail felony is confinement in TDCJ for not less than 6 months or more than 2 years, and the fine cannot exceed $10,000. I see that the plea agreement fits within that range of punishment. So with you understanding the range of punishment and the plea agreement, how do you plead to this charge?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
The court accepts the defendant's plea of guilt. Mr. Adams, any objection to stage 1?
No objection, Your Honor.
All right, stage 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further, Your Honor. We rest.
All right, based on the evidence presented to the court finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement. Court hereby convicts Jessica Lee Attilo of abandoning or endangering a child with criminal negligence, assesses her punishment at 6 months confinement in the State Jail Division of TDC, assesses a $2,500 fine, court cost of $290, reimbursement fee of $35, Court awards Ms. Attilo 43 days credit towards her sentence for time previously served in this case. Ms. Attilo, whenever you get out of TDC, if you do not pay off all of your fines and court costs while you're in custody, or if your family doesn't pay them off, as soon as you are released, you need to report to the Van Zandt County Courthouse so you can make arrangements to pay those. Do you understand?
Yes, sir.
Your failure to do that will result in the court issuing a warrant for your arrest. Now, is there any way that you can get the attention of the jail staff there? So I can speak?
Yes. Yes, the judge is needing to speak to the guy that brought me in here.
And Ms. Attilo, while we're waiting, Mr. Adams has indicated that he has shown you on each document where your signature needs to go. Is that correct?
Yes, sir.
I just want you to make sure that you're very careful in going through there and finding everywhere where it says your name and making sure that you have signed there. And if it says defendant, make sure that you sign there. There's multiple places.
Okay.
Okay. Yes, sir. Thank you. I was going to ask a favor if.
Hold on, Judge.
Oh, yes, sorry.
Sorry, you have to say that again, please.
Okay, yes, I'm sorry about that. I was going to ask if you could do me a favor. Once Ms. Attilo signs everything, can you make sure that jail staff sends either a fax or an email copy back to my court coordinator so that we can file that? And if y'all would be so kind as to fingerprint her on the third page of the judgment. And then if you would drop that in the mail for us so that we can have the original fingerprint.
Yes, sir. We will have our desk officer take care of that for you.
Thank you so much. I appreciate it.
Not a problem.
And if there's any questions or issues, you can call Ms. Patty Taberham, my criminal court coordinator, and she can help.
Yep, we will get in contact with her for any questions, sir.
All right. Thank you, sir. That's all we need today.
Not a problem.
Your Honor, that's all I have on the afternoon docket. I think, may I be excused?
Yes, sir. Thank you, Mr. Adams. And Ms. Attilo, we're going to be adjourned in your case.
Okay.
Thank you, Judge.
Okay, Your Honor, we're ready on Mr. Ashmore and Ms. Thompson's. So whichever one you want to bring in.
Are they both available?
Yes, sir.
I'm going to bring them both in and we'll see which attorney is available first. Ms. Thompson's client will step up.
Mr. Sam.
All right, I believe that there is a writ, WR 2147, James L. Sims. I believe this is a writ of habeas corpus requesting bail reduction. Is that correct, Ms. Thompson?
Yes, sir, for delay, 17-151.
Okay. All right, do you want to call your client or?
Yes, sir.
All right, Mr. Sims, if you'll raise your right hand, I'm going to place you under oath. Mr. Sims, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you need to put your hand down. Make sure you speak up loudly and clearly so my court reporter can take down what you're saying. Go ahead, Ms. Thompson.
Go ahead and state the full name for the record, please.
James Sims.
Mr. Sims, you were arrested approximately on March the 12th of this year. Is that correct?
Yes, ma'am.
And have you been incarcerated continuously for that time since being arrested on March 12th?
Yes, ma'am.
Okay. Now, you had requested a bond reduction back in June, and that was also done for you. Is that also correct?
Yes, ma'am.
And a PR bond was given to you at that time, but you refused to sign paperwork at the jail. Is that also correct?
Yes, ma'am.
Okay. And since that time, you've been in jail approximately about 127 days to 140. Is that correct?
Yes, ma'am.
Okay. And we're here today on what we call a 90-day writ because the state's not ready to proceed to trial. Is that true?
Yes.
Okay. And you're again requesting a PR bond on this. Have you tried to make bond, Mr. Sims?
No, ma'am.
Okay. Is that because you just cannot afford to do so?
Yes, ma'am.
Okay. Have you talked to any bondsmen?
Yes, ma'am.
Okay. I believe you also have other charges in another county. Is that correct?
Yes, ma'am.
And so you have a hold on you for that. Is that true?
Yes, ma'am.
If you were to obtain release today, you actually would not be released. You'd more than likely be sent back to Wise County. Is that true?
Yes, ma'am.
Okay. I'll pass the witness, Your Honor.
Steve?
Mr. Sims, based on your testimony, you were previously, I'm not going to say offered, but a PR bond was basically given to you and you refused to sign it. Is that correct?
Yes, sir.
Why didn't you sign it at that point?
Because at the time, I didn't want my time to stop. Every time continued on, and from my understanding at the time is that 180 days to indict is the limit for the DA to indict. Since then, my mother's had a stroke, and the sooner I can get to the other county and try to get a PR bond out of that county too, I can get it back home to her.
Judge, I have no further questions.
All right, I need clarification. So Mr. Sims has 3 charges: driving while license invalid, aggravated assault with a deadly weapon, and possession of controlled substance, really group 1. Is that right? All 3?
The aggravated assault is in Wise County, Your Honor.
I'm just going off of what Henderson County, what Van Zandt County is showing here on its bookend, which
Yes.
that they're holding for 3 charges, but they're not.
Yes, sir. But I did contact the sergeant, and he confirmed that ag assault was out of Wise County.
And I've got time served paperwork on the misdemeanor charge.
Ms. Thompson, you're seeking a PR bond on the driving while license invalid and the possession charge. Is that correct?
Yes, sir. That's correct.
And state, are you in opposition, or you've already offered a PR bond and Mr. Sims is just, he didn't want to sign it the first time. So are you in agreement with it today?
Judge, we're in agreement, obviously, on the misdemeanor and the drug charge. We were opposed to the ag assault because we believe that, as the court believes, that was here. We've requested information from the sheriff's office regarding that case, and at this point have received nothing. If he's been in for 150 days, I don't believe that the state is in a position really to oppose a PR bond on that charge, even if Ms. Thompson was requesting one, which sounds like she's not, because it sounds like we don't have a hold on him for that, if that is in fact what the sheriff's office is telling Ms. Thompson. So we're not opposed to the misdemeanor and the drug case. I suppose if he is not released on the ag assault and Ms. Thompson believes he should, then we can reconvene at that moment and figure that part out. We are unopposed to the other 2.
Okay, court's going to grant the writ. court will order a $10,000 personal bond on the possession of controlled substance less than 1 and a $2,500 personal recognizance on the driving while license invalid. Court signed that order, and I will have that forwarded to the sheriff's office. So we are adjourned in this
Thank
hearing.
you, Your Honor.
You're welcome.
Out of there.
All right, Mr. Sims, you're done.
Thank you, sir.
All right, we are ready on Casey Ashmore's Mr. Philip Myers.
All right, this is CR 2299, Philip Patrick Myers, set for docket call. Go ahead, Mr. Ashmore.
Judge, one, I want to thank the court for allowing me to appear by Zoom. I just finished a hearing in Groesbeck, Texas. So I appreciate the court letting me move around the cabin. Mr. Myers has an offer of 7 years TDC jail offer to resolve all matters in Van Zandt County, Texas. I got to take responsibility. I thought I had put together plea paperwork, but with this conflict, I wasn't able to get that squared away and get it to him so we could present a decision on this plea or not. I'd ask for, as reluctant as I am, a short reset so Mr. Myers and I can confer about this offer and get our case squared away. So we're back here to plea, Your Honor.
Do you believe that if I put you in a breakout room that you and he could discuss it today and then just make an announcement whether you accept it or reject it?
I do, Your Honor.
You do? Okay.
Yes.
All right. So Ms. Abraham, I'm going to ask that you set up the laptop, and I'm not sure that we have anyone. Do we have anyone else on the jail docket that we need to call? I've got Mr. Mata here, and we can do that in person. Toro's done. Sims is done. Let me look through here. If we have no one else in the jail that needs to be called, and we need to address Miss Foley, who's in Henderson County. Cannon.
We still have.
Go ahead.
We still have Mr. Stevens. He's going over the plea with Mr. Pesnell now in the interview room.
In the interview room?
In the attorney room.
Okay, so if I put the jail court and Mr. Ashmore in a breakout room, then that he should have sufficient enough privacy to talk about it, correct?
We have 2 inmates. Can they go back?
Your Honor, we should be able to fix that fairly quickly. I'm the only uniform in here, so I can't take the other guys back and leave him here alone. I can't call on the telephone either because our new system evidently is interfering with Zoom. But if you'll shut Estella off for 10 seconds while I call to the back, ask for somebody to come get these other 2, then yes, he'll be able to speak with Mr. Ashmore with some privacy.
Okay, that'd be fine.
Thank you.
All right, Mr. Schmidt, are you ready on Mr. Mata?
Okay.
Can you, Mr. Woodwhite?
I cannot hear Mr. Schmidt, Your Honor.
And if you want to, you can use that microphone right there. Will probably help. This one is sticking up. Yeah. Just kind of bend it towards you. There you go.
Yeah, actually, we were here this morning. Mr. Mata had some difficulties getting here. We were sent for a plea. I don't recall speaking to Miss Adam. I'm not certain if they had the papers ready. And obviously, Mr. Mata was able to get here. And so we would ask, I guess, under circumstances to go on your next docket, we could reset it for a plea, come back and do it, whatever.
So what's the plea that he's gonna accept? Probation. We could come back Thursday. We got a docket on Thursday. Wanna do that? Did you hear that, Mr. Woodwhite? Mr. Schmidt's asking to come back and enter into a plea, the probation plea with Mr. Mata.
As long as the court is comfortable with, I haven't heard as to why Mr. Mata was not here. As long as the court is comfortable with resetting it to that, state is comfortable to resetting to do the paperwork and getting it taken care of on Thursday. 2-day reset's not at all a problem for us.
I haven't inquired as to Mr. Mata as to why he was late, but he's made an appearance, and so that I'm satisfied with that. Then what I'll do is I'll reset Mr. Mata till Thursday at 9 a.m. And Mr. Schmidt has indicated that he needs to get the plea paperwork from the state.
And we will prepare that for Thursday, Your Honor.
All right, Mr. Mata, we'll see you back Thursday, 9 a.m. sharp. And make sure you have someone to watch the little one or leave her at home or something. Yeah. And here, you might have, that door may be locked. You may have to come out this way. It's open, okay. Okay, that's fine. Yeah, I didn't. Hey, Mr. Ashmore. Sorry.
Yes, Judge.
Just while we wait, Lauren Foley was set for arraignment today.
Yep.
He is in Henderson County and they are on quarantine, COVID lockdown. So I would just like to reset her for arraignment to September.
Yes, Judge.
Let's see, because the 24th is full, so.
We're back on 14. Is that going to be a problem?
Let's do that. Let's do September 14th on docket.
Yes, Judge. Okay.
I'm just not docket call. Sorry, arraignment.
We're just going to redo her arraignment. Yeah, we're ready on that, and
so we just go get that one checked off the docket, and so we'll wait. We'll wait for the jail to get Mr. Myers to a position where you can talk to him, and then I'll let
you, Judge,
and then you let me know how it goes.
Thank you, Judge.
You're welcome. Hey, give me something to drink while you're there. Thanks.
Got it. I'm not at a bar.
So you say.
Right.
Scout's honor, Judge.
All right.
Your Honor, we're ready for them to be put in a breakout room.
All right. Let me see if I can assign each of you to a breakout room.
I was just gonna let you know that it was.
All right, invitation sent.
Your Honor, if you can hear me, I think we're both back from the breakout room.
Okay, I'll be with you in just a moment.
This is Patty. If you want to go ahead and bring your ringer out, then that should be finishing this up. Thank you.
Are we ready for Mr. Stevens or Mr. Ashmore?
Mr. Ashmore, Your Honor.
All right, I'm gonna let him get situated before I call him.
Some this afternoon is strong. What happened to our video?
Well, let me call him.
Tell him to sit down.
Is he settling?
No.
All right, we are back on the record. This is CR 2299, State versus Philip Patrick Myers. Jail court, you need to turn your video on.
It says we cannot start because.
You stopped it.
Thank you, sir.
All right, Mr. Ashmore, did you have an opportunity to speak with your client about the state's offer, and do you have an announcement?
Yes, Judge, we have discussed the state's offer and the nature of the allegations against my client again, and he is not in agreement with that offer, and we are requesting to be set on the jury docket.
All right, does Mr. Myers understand that the state, or I'm sorry, that the court will not accept any offer, plea agreement in this case after today? Even if the state makes a better offer, the court may not allow Mr. Myers to accept it.
No, I was hoping that you would explain exactly that to him, Your Honor. And you have. Thank you.
All right, Mr. Myers, the court, if you reject the state's offer at this time and I place you on the jury selection docket, then what that means is I'm going to schedule you for jury trial. And we're not going to wait till the last minute before jury and decide we want to take a deal. It's not going to work that way. So today's the last day that you can take a deal. This is it. If you want to go to trial, I will give you that trial and you'll get, if you're convicted, then you'll get whatever the jury gives you, the same, worse, better, whatever it is. The only other way out is you could plead open to the court and you may get the same, you may get less, you may get better. You'll have to take your risk with that. Do you understand that?
Yes, sir, Your Honor.
Okay. All right. We're going to set Mr. Myers then for jury selection beginning August 30th. Mr. Myers, if you make bail in this case, then you're going to be ordered to report to the Van Zandt County Courthouse at 8:30 in the morning, and you'll be greeted by court staff, and they'll give you further instructions until your case is selected for trial. If you are still in jail, then the court will just have a notice of setting sent to you out there. You'll remain on the court's trial docket until your case is reached for trial.
Yes, sir, Your Honor.
Mr. Ashmore, I appreciate you taking the time to meet with Mr. Myers about it, so we didn't have to reset the case.
I appreciate it, Judge. And again, thank you for the opportunity to visit with Mr. Myers in a breakout room and for accommodating my need to be here in Limestone County today. Greatly appreciate it, sir.
You're welcome. Have a great day.
Phil. Okay, thank you. Philip, I'll talk to you soon, sir. Bye-bye.
All right, thank you.
Okay, let me go check on Mr. Stevens.
Yes, ma'am.
David, are you David?
Your Honor,
David? Anything?
we're ready on Mr. Stevens. On Mr. Derringer, I'm sorry.
CO 21-163, State versus James Michael Derringer, except for pretrial.
Yes, that's correct, Your Honor. Judge, I don't have the discovery in the portal yet, so I'll be asking for another pretrial day. I have videos, but I don't have the paper stuff in the portal.
Judge, I'm looking into this right now.
Honor, the only thing I'll show in there is the offense report.
When did you notify the DA's office that you didn't have access to discovery?
Oh, like yesterday, maybe the day, just this week.
Judge, I've just corrected the issue. It did appear that all we had sent was the indictment previously. I've just sent the rest of the discovery over.
Okay. All right, Mr. Stevens, September 14th or September 16th?
Judge, I'm on vacation all that time. I'm out September the 13th through September the 22nd.
What about September 28th?
If I can be late, I have 1, 2, 3, 4, 6 cases set in Kaufman that afternoon at 1:30. I don't think any of them will take real long, but it'd probably be 3:30 in that range before I could get here again.
Okay, fine. So let's set for 3:30 on September 28th.
Thank you.
And state, if there's going to be an offer in this case, will you go ahead and make it to Mr. Derringer so Mr. Stevens can talk to him about it? And maybe since we're quite delayed on this case now due to the discovery issue, and now with Mr. Stevens scheduling, it's going to push us out. We're looking at about 45 days from now for a pretrial hearing. So maybe if an offer can be made, then maybe we can speed the case up a bit since he's in custody.
Yes, Judge. Are you wanting us to make that over Zoom or just by email to Mr.? Okay.
No, by email or in your portal, however you want to do it. I'm just saying if we can make it to him so they can start talking about that. So when Mr. Stevens comes back on the 28th, maybe we can have an announcement other than no contested pretrials or contested pretrials.
We ain't doing that.
All right, you're
That's it.
You're excused, Mr. Derringer. Is Mr. Pesnell ready? Pez,
Yes, sir, we're ready.
is that a plea?
Yes, sir, it is.
And state, can you go, or Mr. Stevens, can someone go ahead and give me the terms?
Yes, Your Honor. This is an aggravated assault with a deadly weapon case. He's going to get, it's a second-degree felony, of course. He's going to get 5 years deferred probation, $4,500 fine. There is $1,250 in attorney fees. And it looks like the court costs are about $290. On front of the judgment, you order, it shows under the reimbursement fees to be $1,270.
Okay, Mr. Pesnell, if you'll raise your right hand, place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Sir, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all of your questions answered?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand?
No, sir. I'm clear.
Is it true that you've placed your signature, your true and correct signature throughout those documents?
Yes, sir.
Mr. Stevens, do you believe your client to be competent today?
Yes, sir, I do.
You've explained to him his legal rights and also the advantages and disadvantages of a deferred adjudication plea?
I absolutely did, Your Honor. I do believe he firmly understands.
All right, Mr. Pesnell, the second-degree felony offense of aggravated assault with deadly weapon carries a range of punishment of not less than 2 years or more than 20 years confinement in TDC and a fine not to exceed $10,000. If the court approves the plea agreement today and places you on deferred adjudication, if you violate any of the terms and conditions of your community supervision, the state could file a motion to adjudicate your guilt. That means convict you. They could bring you back before the court. If they prove to the court through evidence that you violated the conditions of your community supervision, the court could adjudicate your guilt, revoke you, and sentence you in TDC anywhere between 2 years and 20 years. You understand that?
Yes, sir.
Understanding those things, do you still want to go forward with a plea?
Yes, sir.
Mr. Pesnell, how do you plead to aggravated assault with a deadly weapon?
Guilty.
And are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Stevens, any objection to States 1?
No, Your Honor.
All right. States 1 is admitted in evidence. The court takes judicial notice of the defendant's judicial confession. State victim compliance.
Yes, Your Honor. The state has received a victim impact statement in this case, which I believe was forwarded to Ms. Taberham for your review.
All right, is the victim supportive of the plea agreement today?
Your Honor, I have not personally spoken with the victim. However, I do know there's been communication between our office and the victim. I'm just not sure what the official position of the victim is.
So if you can go ahead and just give me the facts to support the plea.
Yes, Your Honor. Mr. Pesnell and the victim are neighbors. They have had a history of disputes amongst themselves. Mr. Pesnell has no criminal history, and essentially one day Mr. Pesnell saw his neighbor in town riding a motorcycle. Mr. Pesnell was in his, I believe it was either a truck or an SUV, some mid-sized vehicle, and he pulled up beside his neighbor, essentially had a fit of rage and swerved towards his neighbor, riding the motorcycle, attempting to run him off the road. Both parties stopped, as did a couple of eyewitnesses, to provide statements to the police. That's essentially how we got here today.
I was reading the victim impact statement, and I'm not sure if it's relative to this case or not, but there's the victim in this case, Mr. Joe White, has made statements about physical assaults, being hit in the mouth, about him having to get out his pocket knife for defense. Is there any facts alleged in this instance that has anything to do with being punched in the mouth or knives being pulled?
No, Your Honor, I'm not aware of anything like that. Like I said, I know that they have a history of disputes between them. I'm not sure about any particular previous contact they've had.
So this has to do with a vehicle swerving at another and the vehicle being the deadly weapon?
Yes, Your Honor.
Okay. Thank you, Ms. Heisel. Anything else from the defense?
No, Your Honor, not for the defense, for the rest.
All right. Then the court, based on the evidence presented, will follow the plea agreement. The court defers a finding of guilt in this case, finds that there is sufficient evidence to convict the defendant, places the defendant on 5 years deferred adjudication community supervision, orders him to pay a $4,500 fine, $1,270 reimbursement fee, and $290 in court costs. Mr. Pesnell, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I want you to go with the deputy, get fingerprinted, and then the probation department will give you further information about what to do next on community supervision. I want to tell you, if you do not have any criminal history, that means you've not been on probation before. And so I think it's important that you understand that each and every one of those conditions of community supervision that you've read over today are equally important. It's kind of like the 10 Commandments. There's not one more important than the other. They're all important. A violation of any one of them can result in the state filing a motion, can result in the court adjudicating your guilt, and can result in the court assessing your punishment between 2 years and 20 years. So it's when, and I want you to understand this, if you and your neighbor keep having problems and you violate your community supervision, and I'm assuming that there's a stay away provision against of the victim in this case. Is that right, Ms. Heisel or Mr. Stevens? Is there a condition?
No, I'll stay away from him.
Well, there needs to be one in there. And if, I don't know, how close are y'all neighbors? Are y'all right next door?
I live on one corner and he lives on the adjacent corner on the same block.
Okay, well, we need to make sure that there's a condition of community supervision in there to stay away from the victim of the case. But what I want to impress upon you, Mr. Pesnell, is that by pleading guilty today, if you decide to drink a beer or smoke marijuana or something like that, the issue when you come back is, did you violate your community supervision? Not did you commit aggravated assault? That issue is already done. We've decided that you've pled guilty. So if you come back and you violate, the ruling is going to be, did you violate or not? And then you'll be revoked on whether you did or you didn't. You will be sentenced on the crime. You understand?
Yes.
Okay. All right. Go with the probate, go with the deputy, get fingerprinted, and then you go with the probation officer.
Thank you, Your Honor.
Ms. Heisel, I do have the victim impact statement and I have signed it and I'll send that back to Melissa.
Okay, and Judge, with respect to the condition of probation for no contact, we were concerned that a geographic restriction would impact Mr. Pesnell. So would the court just like a no contact in any manner with the named victim and not have geographic? What would the court propose? Because we'll need to get those amended conditions presented to him at his first probation check-in.
Yes, so consult with them to see what the distance is between the homes. Maybe the geographic can apply. If they live within that geographic restriction, then we can just modify the terms to be no contact with. And that's the heart of my concern is no in-person contact, no social media contact, no telephone. You know, the fact that you live close together, that's not going to be a violation. But if you drive down in front of his house and you sit there, that's going to be different.
You're not having any troubles with me, Your Honor.
I hope not. So what I'll do is, Ms. Burns, I would ask that you just speak with Mr. Pesnell to find out about how far apart they live. Let him give you the estimation, or Mr. Stevens can, and then let's put a condition in there that's appropriate for him.
Yes, sir.
Thank you. All right.
Your Honor,
Yes,
I've
sir.
got one more. I've got one more, Judge, to do, and it's the guy that's got COVID or COVID symptoms. I'm going to go meet with him in the car, get the papers done, and come back in.
Okay.
And
Yes, I was going to.
intervene soon.
Excellent. Okay, I'll stand by for you.
Thank you, Judge. Yeah, you're out of here.
Hang on a second, I'm about to respond.
Mr. Abraham,
Yes, Your Honor.
is Mr. Blevins going to zoom in from his car?
Yes, sir.
Yes. Okay.
Yes, sir.
Just remind Mr. Stevens that, paperwork can still transmit. So if there's a legitimate concern, I know we're kind of just being cautious on him, but I would just be mindful of that.
We'll give him a pair of gloves.
All right, thank you. Are we ready on Mr. Blevins?
Come back and check on you.
Your Honor, Miss Burns is typing.
I was not aware of the plea, sorry.
Okay, just let me know whenever y'all get ready.
Okay.
Mr. Blevins, just hold what you got. We'll be right back with you.
Your Honor, we believe we're ready now. What degree was that?
It's a second.
Second degree, 3 year. Okay, thank you.
All right, this is cause number 016-397, State versus Richard B. Blevins. Mr. Blevins, if you'll raise your right hand, I'm going to place you under oath. Mr. Blevins, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You're on mute, so you can put your hand down. I'm going to ask you to press that button on your phone.
I got it. Thank you.
All right. Do you swear?
I do.
All right, you may put your hand down. All right, you are Richard B. Blevins, right?
Richard W. Blevins.
W. Blevins?
Yes, sir.
Judge, we just discovered when we were signing the papers minutes ago that his middle initial shows B like boy. It should be W like William. And I believe it's been that way probably throughout.
It
even when he
has.
first got probation.
Well, the state's motion to adjudicate appears to be correct. So, okay, so it's Richard W. Blevins. Okay. Mr. Blevins, you were previously placed on community supervision by this court on August 7th of 2018. You pled guilty to aggravated assault with a deadly weapon, a second-degree felony. The court deferred a finding of guilt, placed you on community supervision for 5 years, and has also assessed a $4,000 fine. Since that time and during your community supervision, the state has filed a motion to adjudicate and revoke. Have you had an opportunity to review that with your attorney, Mr. Bill Stevens?
Yes, sir.
Mr. Stevens, did your client waive the formal reading of state's motion to adjudicate?
Yes, sir, we do.
Does he intend to plead true to all counts alleged?
Yes, sir. Yes, sir. He pleaded through every count.
Right. And Mr. Blevins, are you pleased with Mr. Stevens as your attorney?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed that you do not understand?
No, sir.
And you have placed your true and correct signature throughout the documents?
Yes, sir.
All right. And Mr. Stevens, can you tell me what the proposed plea agreement is?
Yes, Your Honor. It's to adjudicate him guilty, sentence him to 10 years TDC, suspend that sentence, place him on supervision for 3 years. Balance of the fees and the court costs previously unpaid would roll forward to the new case here. That's pretty much it in a nutshell, Your Honor.
Okay. All right, Mr. Blevins, understanding the plea agreement in this case, is that your understanding and is that your agreement to plead guilty in exchange for the state's recommendation that your sentence be assessed at 10 years confinement, suspended for 3 years community supervision with a balance of all your financial obligations?
Yes, sir.
Okay. Understanding the plea agreement then, Mr. Blevins, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, and 6 as a the state's motion? Are those counts true or not true?
True.
Are you pleading true because in fact you did commit those violations?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true today?
No, sir.
All right, court will accept the defendant's pleas of true. Mr. Stevens, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A?
No objection, Your Honor.
All right, State's A is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. I just wanted to state for the record that the state, before offering, it's not really reinstatement, but before placing Mr. Blevins back on probation, I did consult with the probation department, and his probation officer was in agreement with this resolution, which is putting him back on probation.
All right, thank you. I do appreciate that. Anything further from the defense, Mr. Stevens?
No, Your Honor, we're resting close.
All right, Mr. Blevins, so tell me before I decide if I'm going to accept or reject this, tell me why I should put you back on probation if you're not going to show up, you're not going to report, you're not going to do the things that I already told you to do. I mean, are we wasting our time here?
No, sir. Both my parents, their health is deteriorating quite some in this past couple months, and I've had to move back in with them to help them. And I'd like more than anything to be able to stay in the situation I'm in now and not have to go to prison. I know my word isn't much to y'all as it is now, but I'm going to do better.
What are the circumstances that have changed that are going to enable you to do better?
Being able to spend as much time with my parents as I can before they go. I mean, my dad has cancer and diabetes, and my mom is now on hospice.
So you understand, if you fail to show up, you fail to report, you're telling me that if you violate, you know you're going to prison for 10 years.
Yes, sir.
It's not up to 10. You're going to go to prison for 10.
Yes, sir.
So the agreement is today, you agree, I agree to place you on community supervision, and I order that, and you're going to go and do it. And if you don't, then you're telling me, Judge, I agree. If I don't do that, I violate, I screw up. I agree. I'm going to come in. I'm going to accept my 10-year sentence and go to prison.
Yes. Yes, sir. And I've already set up my next probation appointment. It's next Tuesday. I've gotten that taken care of as well.
Okay. All right. Then based on the evidence, court finds that Mr. Blevins has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court will adjudicate Mr. Blevins' guilt, convict him of aggravated assault with a deadly weapon, a second-degree felony, will assess his punishment at 10 years confinement in the Texas Department of Criminal Justice, will suspend that sentence and place him on 3 years community supervision and order him to pay the balance of his financial obligations. Has Mr. Blevins already been fingerprinted?
Not today.
I believe so.
Okay, well then we'll need somebody to go out and secure a fingerprint from Mr. Blevins before you leave. Okay, Mr. Blevins. So say
Yes, sir. We'll take care of that, Judge.
okay. After you get fingerprinted, then Mr. Blevins, you're free to go and then report to probation as they instructed you. You understand?
Yes, sir.
Okay, we'll send somebody out there right now to get your fingerprint and then you can go.
Okay, thank you.
You're welcome.
I'll be excused, Your Honor.
Yes, thank you, Mr. Stevens.
Thank you, Judge. Appreciate it. Judge McKee said say hi.
Judge McKee?
Yes, sir. I just left him a couple of years.
Hey, so now,
Deputy
I'm sorry, say that again, Patty. I can't hear you.
Deputy McLeish is going out to do the fingerprints.
Okay. All right, thank you.
And I'll see you back at the courthouse.
All right. So, Mr. Blevins, you can turn off your device and the deputy out to get your fingerprint.
Okay, thank you. Okay.
You're welcome, sir. All right, I believe that's a wrap. Is there anyone that, yeah, what about Blake Ekrit? I meant to text Karen to see if he showed up.
Judge, as far as I'm aware, he did not show up. I know that probation presented a motion to the state earlier, which we signed. So I anticipate that's going to be filed right here soon.
Yeah, well, she's already brought it to me and I signed it before we ever left. So let me pull what you got. Let me call Karen and we'll see.
Yes, sir.
Hey, Blake Ekrit. Did he show up?
He never showed up.
He never showed? Okay.
No, but we have the warrant active and they were entering it in today.
Okay, well, Carl gave him the talking to, right before he left.
Well,
So.
I did